The coins alert is the source of all of the information that is described in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? In an ongoing legal dispute with the SEC, Ripple has agreed to pay a fine of $125 million as part of a regulatory dispute that has been going on for a considerable amount of time. Ripple Group is getting ready to issue a bond to the United States Securities and Exchange Commission that is worth $125 million. During the course of this legal proceeding, which has been going on for more than 3 years, allegations have been made that the corporation engaged in an unregistered investment offering by means of the distribution of XRP. In a case that is being closely followed by the community of digital assets, the imposition of the fine, which is substantially less than the almost $2 billion that the SEC had first sought, is a significant event that is being monitored by a large number of people, whether the verdict of the court will have an impact on Ripple. On August 8, 2023, a federal judge issued an order that required Ripple to pay the assessment of $125 million. This order was issued following the issuance of the ruling. As a direct consequence of this ruling, the initial requests that were made by the SEC have been drastically decreased. A maximum of $10 million was proposed by the company, despite the fact that they had previously expressed their disagreement with a lesser fine. A compromise between both sides is indicated by the ruling of the court, despite the fact that Ripple will still incur significant costs as a result of the verdict. In July of 2023, Justice Ana Lisa Torres made a ruling that led to the creation of this law. In that decision, she came to the conclusion that XRP did not represent an assurance. The court came to the conclusion that Ripple's marketing of XRP to institutional investors was in violation of relevant securities legislation, which led to the imposition of sanctions. It was believed by Ripple that this was a success to some extent. However, the court came to the conclusion that there was an additional violation. As a direct consequence of this discovery, a contentious discussion on the manner in which crypto should be mandated has emerged. The Securities and Exchange Commission (SEC) has until October 6 to submit an appeal against the verdict that was handed down by the court. The agency, on the other hand, has not yet divulged its planning procedures. There is a steady amount of speculation regarding the topic of whether or not the Securities Exchange will dispute the decisions. Many individuals are of the opinion that an appeal might potentially broaden the scope of the constitutional discussion and have an effect on the internet marketplace for virtual currencies in a more significant manner. According to a statement that was made by Stuart Alderety, the chief legal officer of the corporation, he is confident in the decision that was made by the court and that it is unlikely that an objection will have an effect on the conclusion. He remarked that the careful study that the legal system does offers little possibility for novel arguments to be presented, in addition to pointing out the low success record of comparable appeals. He also mentioned that the comparable appeals had a low success rate. The prospect of an incentive is still present, however, the consequences of such an incentive could have a considerable impact on the situation. The Ripple v. SEC case has substantial ramifications for the cryptocurrency business, particularly with regard to the regulation of digital assets. These repercussions concern the regulation of digital assets. It is possible that the fact that the court has ruled that XRP is not a security, in conjunction with the decrease in the sentence, will have an effect on other cryptocurrency initiatives. This case throws insight on the challenges that are experienced in continuous arguments that take place in the United States regarding the restrictions of cryptography. As the organization prepares to pay the penalty that was given, which is worth $125 million, the industry is keeping a close lookout for any new events that may occur. Over the course of the past couple of years, Ripple Labs has been the topic of a great deal of talk over the likelihood of the firm registering for an initial public offering IPO. The chief executive officer of the company, Brad Garlinghouse, presented a presentation during his presentation at the conference. This presentation was given at the fireside discussion that took place today at Korea Blockchain Week, which is now being held in Seoul. Garlinghouse discussed a wide range of topics, one of which being the idea of acquiring financial resources by means of an initial public offering in the United States. At this time, the chief executive officer has declared that they do not have any intentions to go public in the country. This was in answer to a query that was asked about it. This predicament is mostly attributable to the stance that the United States Securities and Exchange Commission has taken toward the entire industry and not just Ripple in particular. He went even farther and suggested that persons stop from incorporating their firms in that region because if they do so, they are just asking for more legal fees. He went to such lengths as to indicate that he recommends that individuals refrain from doing so. It is important to keep in mind that the United States Shares and Exchange Commission has initiated a significant legal action against Ripple, which is estimated to cost several billions of dollars. The lawsuit alleges that the company has participated in unregistered placements of shares. Prim and foremost, the Commission maintains that its native cryptocurrency, XRP, ought to be subject to the legislation that governs securities. This is the primary argument that the Commission makes. In contrast, United States Judge Annalisa Torres issued a ruling not too long ago that partially contradicted the position taken by the Securities and Exchange Commission. The stated fines imposed by the SEC were reduced by more than 90%, bringing the total amount to around $125 million. Additionally, she reaffirmed her prior finding that XRP, which is traded on secondary markets, does not comply with the definition of a securities. The launch of Ripple's stablecoin has taken place. In addition, the company is planning to create its very own stablecoin, which will be referred to as Ripple US, DAY, as Crypto Potato revealed earlier in the month of August. Garlinghouse also addressed this topic during the conference, providing specifics on the fact that they are currently taking part in a private kind of closed beta, and that Rulu has been minted within the framework of this framework. In addition, Garlinghouse provided information regarding the fact that they are currently engaging in this beta. Furthermore, he specified a timetable for the launch, indicating that it is believed that the launch would take place within weeks rather than months, and that it is anticipated that the launch will take place. Brad Garlinghouse, the chief executive officer of Ripple, recently made the announcement that the company is moving closer to launching its new stablecoin, which is going to be called Ripple USD. The launch of Relest is scheduled to take place within the next few weeks, and the project is now in the closed beta phase. Ripple's existing xrp+ were the inspiration behind the creation of the stablecoin, which was designed with this objective in mind. In a market that is dominated by USD and USDC, a new alternative will be made available, and it will be accessible on two separate blockchain networks. This alternative will be made available and accessible. According to Garlinghouse, Ripple has the intention of utilizing Rulus in order to fulfill the requirements of the market, particularly after the USDC was debugged 18 months ago. The significance of this cannot be overstated in light of it. He went on to argue that this provides Ripple with an opportunity to intervene and provide an option if they choose to do so. Due to what he referred to as a hostile regulatory climate, Garlinghouse expressed his strong displeasure of the United States Securities and Exchange Commission, despite the fact that the stablecoin was the topic of positive news media coverage. He asserted that Ripple does not intend to carry out an initial public offering in the United States of America. The chief executive officer of Ripple has voiced his disapproval to the Securities and Exchange Commission (SEC) and has suggested that cryptocurrency be made more transparent. A number of contradictory actions have been made by the Securities and Exchange Commission (SEC), including allowing Coinbase to conduct an initial public offering and then subsequently suing the exchange for engaging in activities that it had previously allowed. It was strongly recommended by Garlinghouse that other Bitcoin firms avoid incorporating in the United States. He was the one who made the statement, "It doesn't sound like a lot of fun to me to try to go public in the United States with like a very hostile regulator that has approved your S1. Additionally, the speaker stated that Garlinghouse went over the recent enforcement action that was conducted by the SEC against the OpenSea NFT marketplace. In his statement, he referred to the action as sad and proposed that non-financial instruments, often known as NFS, should not be classified as securities. In the future, he believes that elected officials, rather than the Securities and Exchange Commission, might be the source of legislative certainty.